Good afternoon, ladies and gentlemen. This is Professor Magda Slabbert. This is your first webinar for Introduction to Medical Law. Welcome and thanks for tuning in, and I really hope that I give you something to think about or that will help you with passing this module. Okay, first of all, who am I? I am a professor at the University of South Africa. I teach professional ethics, but my real passion is medical law, and I've been doing this for LEAD for the past 4 years. Who is Bonnie? Bonnie used to be a master student of mine. She is now busy with her doctorate and very skillful, very knowledgeable. So we work together. Although Bonnie will be the facilitator, I am in the background. So whenever Bonnie is unable to answer any of your questions, she will revert it to me, but you are welcome to ask. This webinar is a recording. Therefore, I cannot deal with your questions while I am busy with the lecture. But please make notes if you have questions, and then you can send it to Bonnie, or you can post it on your forum, and then either Bonnie or myself will answer it. Okay, so we want to know a little bit about you. Who are you? So please introduce yourself on the forum, just short. Say how old you are you working, are you an attorney, why are you doing this course, so that we just get a sort of a feeling of our students with whom we are dealing with. And then remember, you are welcome to ask questions on the forum, and your fellow classmates or your fellow students can answer it, or Bonnie will answer it, or she will revert it to me. And then just remember, we cannot help you with any administrative matters. There you will have to ask Grace Makuru, who is very good at answering all administrative matters. You will see on your website that there's a schedule, and that Bonnie will be online once a week to answer specific questions. But as I know Bonnie, she will look more or less on a daily basis and will help where it's possible. Then also look under announcements, because if there's interesting cases that we come across or we want to share anything with you, she will put it either under announcements or on the forum. This slideshow of this webinar will also be made public to you. Unfortunately, it is against LEAD's policy to make the recording available, but you will have access to the PowerPoint. So don't worry if I go fast and you cannot write down the court case that I'm referring to. You will get the slideshow, so you will follow up, and then you will hear me in the background in your head, but there's ample time then on your own to work through the slideshows. Test 1 is based on all the work. In other words, all the work in your study, your official study material. You must go through all of it. And then when you feel you are ready to be tested, you will log on to test 1 and you will do the test. That will contribute 20% to your final mark at the end. But it will open up at a certain time. It will be open, I can't remember correctly, but maybe for a week or longer. But you log in when you feel you are ready. But it is all the course material, not all the extra that we give you under announcements or that Bonnie will draw your attention to. That is not part of test 1. Test 1 is only based on your official study material as you find it on the web. Then how do we work? We have activities. Bonnie will open up an activity every week. So you will have a week to complete the activities. And then after you have done 3 activities, for example, activity 1, then activity 2, then activity 3, then you will combine the 3 activities, make it one document, and submit it as a portfolio online. It must be in PDF format, Please remember to have a sort of a title page, your name, and then just indicate that it is activities 1, 2, and 3. Number your activities, otherwise it becomes difficult for the marking. But plan your time. You cannot wait until the evening before the portfolio needs to be submitted. You will run out of time. The activities are wider than the study material. You will be expected to do extra reading, and therefore it might take quite some time. So that is why you are given a week to complete an activity, and try the best to your ability to do it. Otherwise, you are definitely going to run out of time. You've paid for this course or this module, and we want you to pass it. But you will have to plan your time. We do realize that some of you are working for law firms and you are busy. Maybe there's a court case coming up. Talk to us, then we will try to accommodate you. But I cannot emphasize this enough, that you need to plan your time and do your activities as it is posted. Then be active on the forum if you want to. If you can't find reading material or a court case, ask your other students, your friends, to help you. But at the end of the day, you have to do your own work. And then I just make the comment, don't give up. You have paid for this module, and therefore, not that you have a right to pass it, but we will do everything from our side to help you. So never just give up and decide it is too much. At the end, your 2 portfolios will count 80% of the final mark. In other words, test 1 that I've spoken about is 20%, and then the 2 portfolios is the other 80%, and those 2 will then be the 100% for your final mark. So please put in an effort. As I've said, the questions that we ask in the activities are broader than the study guide. You will not find the answers in the study guide. The study guide will help you or give you the background so that you understand the question, but then you will be given extra reading, maybe a court case, and then you need to answer it. So it is quite time consuming. So activity 1, 2, and 3 becomes portfolio 1, and activity 4, 5, and 6 becomes portfolio 2, and the 2 portfolios, portfolio 1 and portfolio 2, is then 80% of your final mark, counted with the 20% for test 1, and that is your final mark at the end. Okay, each activity, how do we look at the activities? It is assessed in total. So first of all, we want to see whether you understood the question. Then we want to see whether you did that what was expected of you. In other words, did we want you to go through a court case? Did you actually read the case? Did you answer from the case? Or if we gave you extra reading, let's say from the National Health Act, did you actually read it and did you understand it? Then, of course, the main thing that we test is whether you understood the principle that was tested. In other words, was the reading material on medical negligence? Was it perhaps on a blood donation for Jehovah's Witnesses? Was it about the HPCSA or a disciplinary hearing? So we want you to find the issue that we're testing. Is it an issue about informed consent? Is it an issue about the Consumer Protection Act? Is it an issue about children in medical law? So that is the main thing. We want to see whether you've identified the correct principle. Then, of course, generally, we just look whether you've put in an effort. And then lastly, at the end of the day, we can see whether you enjoyed it and whether you are proud of it. So Whatever you do, do it in detail. Feel proud of it. Make it your best effort. Then, of course, it will reflect and we will give you the necessary marks. Okay, so let's go to the work. The study material that you received is not original work. It is a combination of work from different experts that I have compiled, and therefore I don't want to have all the credit because it's based on other people's work and other experts. So the books that I indicate here, they are not prescribed. In other words, do not rush to the nearest bookshop and try to buy all these books. They are quite expensive, but if you plan on becoming an expert for legal advice on medical law cases, these books that I've listed there will help you a lot, and you can basically not go without them, but they are not prescribed for you in order to pass this course. So those are extra books that will one day help you when you become a legal advisor on medical law issues, or whether your practice then starts doing medical law cases. The first one is Carstens and P. Mayne, Foundational Principles of South African Medical Law. It is a 2007 publication and it is out of print currently. So you will not be able to find a new book. It will not help to go to LexisNexis and try and find the book because the book is out of print. It's being updated, and we hope that the updated version will be available early next year. It should have been this year, but with the coronavirus, everything fell apart a little bit, and it will be available early next year. But maybe if you are on social media, just ask if someone has that book or whether you can buy it secondhand, because it's an excellent book to have. It's a thick book, and it used to sell for about 700 Rand. So if you can get it secondhand for a few hundred less, invest in it and buy it. It's a good book to have. The next one is Dye and McQueek Mason, Bioethics, Human Rights and Health Law. Also very, very interesting, focusing a little bit more on human rights, but it's informative. It's a nice book to have. It was published in 2011. That book is also being updated, so maybe you can also find a second-hand one of 2011. The new one will be on the shelves early 2021. The next one, Moodley, Medical Ethics, Law and Human Rights. That is necessary if you want to specialize in human rights. There's already an updated version available from Van Skyke Publishers. So if you go onto their website, you might find it. Then McQueek Mason and Dada, the A to Z of medical law. That I would suggest that all of you buy and have it on your desk, because it's like a dictionary. It's very concise. It will not give you detail. But let's say, for example, a client sits in front of you and they want legal advice on in vitro fertilization. Then you can quickly go through the book, get a few notes. It will refer you to other possible topics, and you will easily see where to go. So that is a nice reference to have. It is not complete, it will not be enough, but it will help you to guide you where to go and look for certain answers if you are faced with a medical law question. Van der Heever and Lawrenson, Expert Evidence in Clinical Negligence, a 2015 publication. Excellent book, excellent. If you are going to specialize in medical negligence cases, then you actually cannot do without that book. What is also very good about that book is it helps you and it indicates to you step by step how to get documents from hospitals or from doctors. Remember, if you start a medical law case, you will have to ask for the documents, and that book helps you and indicates to you and which sections of the different laws that you can apply. But it also helps with the prepping of your expert witness. Where do you find an expert witness? How do you conclude an agreement with an expert witness? What is expected of an expert witness? Excellent book. So I will definitely suggest that you get hold of that book. The next one, John Sainer, he is a senior counsel. That is Loose Leaf, and it is published by LexisNexis. So maybe the company can buy it, as it is very expensive, but it is updated regularly. So also a very, very, very good book to have on your shelves if you are going to go into medical negligence. And then the last one is just on the quantum. That is how to determine the amount that you are going to claim of what happened to a body or a fatal injury. In other words, what and how do you determine the quantum? That is an added extra, because usually you will give it to a person who is an expert in that field, who is not an auditor, an actuary. Usually the actuary will do all the calculations for you, but if you want to have a quick reference, then that is a nice book to have, as it is updated in 2019, so it is very recent. And then never ever forget about the HPCSA booklets. Never forget about that, because that also gives you an indication of what is expected of medical professionals. And you will find these booklets electronically on the website of the HPCSA. So you do not have to buy it. You go to the HPCSA and you see you want something about confidentiality, then it might be booklet 5, and it will give you everything that is expected of a health professional concerning confidentiality, or where it concerns informed consent. You just go to the website and you look for the booklet on informed consent. So that will help you to find answers in order to build your case, should it then go for litigation. So what's the outcomes for this module? First of all, we're going to look at the Constitution and the impact that the Constitution have on healthcare and access to healthcare services. Then we are going to look at the doctor-patient or the hospital-patient relationship. We are going to focus on medical negligence and how it impacts on civil and criminal litigation. We are going to look at the various grounds of justification for medical interventions. And then lastly, we are going to look at the influence of legislation on the practice of medicine and access to healthcare. And then you will see in your study material, there are at the end practical exercises. These are just for yourself, just to get an idea what a case looks like, etc. In other words, we are not going to discuss these practical exercises in detail, nor are we going to give you the answers, because it will differ from person to person how they will approach it. Okay, in this webinar, I'm definitely not going to cover all the outcomes. You would have seen on your schedule that there are 3 webinars. So this is the first one, and then there will be a second one and a third one, and in all 3 of them, these outcomes will be covered. Okay, now before I officially start, I want you to read with me a quote that comes from a case of a private medical institution, Mediclinic versus Vermeulen, and it was in 2015 in the Supreme Court of Appeal. And the judge made the following comment. We should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than the good of their patients. Initiative would be stifled and confidence shaken. A proper sense of proportion requires us to have regard to the conditions in which hospitals and doctors have to work. We must insist on due care for the patient at every point. But we must not condemn as negligence that which is only a misadventure. This is so important. So the first thing that you must remember from today's webinar is that everything that goes wrong in a hospital or with a doctor is not necessarily medical negligence. In other words, if a client goes to hospital and there's an operation, but the outcome is not what was expected, it cannot automatically be because of negligence. It will depend on a lot of facts. So every person that comes to you as a client that is unhappy, listen to what they say, but do not condemn it as negligence if it is just a misadventure. Okay, this is just an introduction. As we go through this whole module, you will get to know how to test for medical negligence and what should be proved, etc. But just remember that everything that goes wrong in a hospital is not necessarily negligence. Yeah, I've just given you something from Google. It's a bit blurred and also a bit old. But yes, medical negligence is a huge issue in South Africa. Now, just to give you background, how does medicine or health works in South Africa? We have the National Department of Health. But according to the Constitution, health is a provincial responsibility. In other words, we have the National Department of Health, and then we have 9 provincial departments of health. And then at the head of a province is the Premier, and then he then appoints a person which we abbreviate to the MEC, a member of the Executive Committee. And that person is then responsible for health in that province. So if something goes wrong in a public hospital, then you will sue the provincial department and it will be the MEC of health. National government gets a certain amount of money which is allocated by Parliament for the Department of Health. Then it is allocated to each province. Now, with that money allocated to the province must pay the salaries, the province must buy equipment, the province must sustain the hospitals, etc. So, and the budget is only that big. Now, if there's a lot of medical negligence claims and government is guilty, or the people working for government, the doctors or the nurses, it is proved that they were negligent, then the amount claimed need to be paid out of that provincial budget. And that is a huge problem, because where children is involved, sometimes the claims can be up to 20 million rand. Now, if you pay 20 million rand for damages for one case, then it is 20 million rand out of your budget. And then there's not enough left to buy more equipment or resources. So yes, medical negligence is a huge problem, and there's a lot of speculation how to deal with it, because it's draining the budgets of the different provinces and it is not sustainable. It cannot go on like this. To get more background, to see the problem and the number of medical negligence cases, etc., please go to the website of the South African Law Reform. I've given you the website there. Then try to find Project 141, paper 33. This is excellent for you to see the extent of medico-legal claims, but the document is also very informative because it explains what medical negligence is, and it has a list of all possible court cases on medical negligence. So it's a nice to have, it's worthwhile, it's a bit outdated, but go and see it because it will help you. It will, because then it's not just me giving you the information or lead in your study guide. You will see the bigger picture and you will immediately see the problem and why something needs to be done about all these medical negligence claims. Then I would also like you to go to the website of Corruption Watch. You can just Google Corruption Watch. You will go to their website and there's a document with the title X-ray, the critical state of the health sector in South Africa. And that is also quite an eye-opener to see what is wrong in the hospitals, to see the problems. And then you can think for yourself, what could be the possible answer? Will the NHI, remember the National Health Insurance, which is not implemented yet, they are envisaging it for 2026, but I think COVID have put them back a little bit. But just see and start thinking in your mind whether South Africa is ready for the national health insurance and what could or should be done with all the problems, especially in the public sector. Although, as we carry on through this module, you will see that the private sector is also guilty in a big sense with negligence cases. But okay, so the South African Law Reform, that paper 33, Project 141, it is not prescribed. You do not have to study it. You will not be tested on it. Neither the Corruption Watch one. All that we want you is to go there and see the extent of medical negligence or the state of the hospitals in South Africa. Okay, then you will see that sometimes people speak about healthcare, sometimes about medical law, sometimes just about medical negligence. It is just different concepts. So healthcare law is wider than just medical law. And remember that medical law is not necessarily only medical negligence. If you study medical law, it also includes things like surrogacy, in vitro fertilization, mental health care. It covers a lot of topics, not just medical negligence. Healthcare law, healthcare workers are broader than just doctors. In other words, it's physiotherapists, speech therapists, the allied health workers, all these people that register at the HPCSA and all the legislation that they work in and that cover them. I've mentioned that when you sue a person in the public sector, it will be the MEC, the member of the executive committee or member of the executive council. So remember, South Africa has a two-tier medical system. We've got a public sector and we've got a private sector. In the public sector, that is where you do not pay if you have nothing, or if you do get a salary, you pay according to your income. In the private sector, of course, you either pay yourself or you are a member of a medical scheme or a medical cover or medical insurance, and then they pay the private sector. But this is very unique And that is the bottom line that you should understand, that South Africa is quite unique in that we have two sectors, a public sector and a private sector. Now, what we are going to focus on today is basically the Constitution and medical healthcare law or medical law, because the Constitution is always in the background. You must always first and foremost determine whether a right in the Bill of Rights has been breached, and then you take it from there. So the Constitution should always be taken cognizance of, but I will help you and we will go through the detail. Then remember, when there's no damages, there's no claim. And this people find difficult to understand. And I'm going to explain it to you by way of an example. Say, for example, I've got a 19-year-old son, therefore he is an adult, but he still lives with me because he's a student. So he doesn't support anyone. He lives with me, but I still take care of him because he's a student. So he goes out one evening, had a few drinks, and on the way home, there's an accident. He goes to a public hospital, and because of negligence there, not because of the accident, but because of the negligence at the hospital, he dies. Can I now sue the MEC? No, I can't. Because what damage did I suffer? Yes, I lost my child. Yes, that is terribly sad. But I cannot attach a rand value to my child. I cannot attach a rand value to my pain, my suffering, and my loss. Therefore, even though there was absolute clear negligence, I can do absolutely nothing because I cannot prove a rand value that I can claim for damages. So if there's no damages, there's no claim. You have to understand this. If a client sits in front of you and they want to sue a doctor, whether it be in the public sector or the private sector, first of all, try to determine what the damages are that you are going to claim. If there are no damages, you have no claim. Let's take the same scenario. My son is 19, an adult. He is staying with me because he's still a student, and there's an accident, and he goes to a hospital. This can be private or public. And because of negligence there, he becomes a paraplegic. Then he can, remember he's an adult, he's above 18, but even if he was younger, then I could have done it. He can now claim a lot of money. He can now claim for his loss of the amenities of life. He can now claim for pain and suffering, being a paraplegic. He can now claim because, let's say, he would have been a chartered accountant and now he has a little bit of brain damage and he will never be a chartered accountant, but he would have been B1 for 30 years. So all that calculations is done, and then a claim will be instituted, let's say for 25 million rand. Now you have a claim. Do you see what I'm saying? Let's take away that it's my son. Now it's my husband who is the breadwinner. If he now ends up in an accident or whatever reason goes for an ordinary small operation to hospital and there's damage and he dies, then I can sue either the public hospital or the private sector hospital because they have taken my breadwinner away. And now an actuary can make calculations of what financial damage I suffered because my husband died. and that will be the amount that I will then claim. So you have to remember, if there's no money, if you give birth to a stillbirth baby because of negligence of the maternity ward at a hospital, you cannot institute action because you have suffered no damage. That baby does not have a rand value. I know it sounds cruel and I know it's sad, but that is the way our legal system works. In order to be successful with a medical negligence claim, you have to prove all the requirements for a delict. Now, those of you who has done the law of delict, you will remember what are the requirements for a delict. First of all, there must be conduct, human conduct. The conduct must have been wrongful, and you determine that by way of public opinion. There must be fault in the form of intent or negligence. In the field of medical law, it will nearly always be negligence, because I don't think any doctor would by intent cause harm. Then there need to be causation. In other words, a link between what happened in hospital or what the doctor did and the damages that you suffered. And as I've said, the damages must be provable. So if your client enters your office and starts talking about what went wrong in a hospital or what a doctor did, in your mind, you should quickly see whether there was conduct, whether it was wrongful, whether there was fault. And the biggest problem to prove is causation, that there is a causal link between what the doctor and the hospital did and the damages that you suffered. That is a delict. Now, those of you who have already finished your LLB degree, you also did the law of contract. Can you still remember what are the requirements for a contract? Okay, it's basically that there must be a coming together of the minds. You must have contractual capacity. It must be legally possible. It must be physically possible. And then, of course, also damages. But now, what is the difference between claiming on the basis of a delict or claiming on the basis of a breach of contract? And this is also very important of today's seminar, the answer to that question. Okay, those of you that did an LLB, you should know it off by heart. Under the breach of a contract, you can only claim actual, physically provable rand value. But under a delict, you can claim pain and suffering. In other words, but remember, you can claim pain and suffering if you are the person that's being hurt. As I've said, when my son dies, me as the mother cannot claim pain and suffering. But if my son did not die, but became a paraplegic, he can institute a huge amount for pain and suffering and the loss of the amenities of life. So that is very important that you understand the difference between when you claim on the basis of a breach of contract or when you claim on the basis of a delict. In medical law, when you want to institute an action, you can go either way. In other words, you can claim on the basis of a delict, or you can claim on the basis of breach of contract, or you can do both. It is up to you. But you will see that I will only give you an example of one case that is based on a breach of contract, as the majority, nearly all medical law cases that goes to court will be on the basis of a delict, because you would like to claim pain and suffering. Usually when you go to hospital, there will be a contract between you and the hospital. And of course, if you go and see a doctor, there's immediately a contract between you and the doctor. But the safest way is to institute a claim on the basis of a DLIT, because if you can, you should claim pain and suffering. So either both or one of them, depending on the circumstances. Just by the way, I will stop at some stage when I see on my clock that I've spoken for an hour. I will give you a body break for about 5 minutes so that you can just stretch and keep your mind together and maybe record a few questions. And then I will give you a 5-minute break, and then we will start again so that your ears can just stop listening to me. But it's not an hour yet, so I'm going to carry on a little bit. Okay, as I've said, the Constitution is always at the background. Now, in the Constitution, there is in Section 9 the right to equality. And as I've said also, we have a public sector and we have a private sector. Now you should understand this. If you go to a doctor or a hospital in the public sector, then the doctor and all the nurses, the physiotherapist, the speech therapist, the psychiatrist, all of them are employees of the state. And because they are employees of the state, and our Constitution has something like the right to equality, if you work in the public sector, you cannot discriminate at all. You will have to treat each and every patient that you meet. You do not have a choice. You are an employee of the state and you must look after everyone. It doesn't matter whether that person lives under a bridge and is dirty and smell of alcohol and didn't bath for months, and that person comes to you, you have to. There can be no discrimination. Remember this, even in the case of an abortion. If a girl child, the Choice on Termination of Pregnancy Act gives any girl of any age the right to have a lawful abortion. If a girl then comes to you or the doctor in the public sector, he or she cannot refuse. Yes, they can if it is against their religion or their culture, but what they cannot do is just blatantly refuse to do it. They have the duty to refer that girl or that lady or whoever to a doctor who will do it, who will be able and who are willing to do it. But you cannot just refuse, because then you are not applying the legislation of the country, and you are basically an employee of the state. So remember that in the public sector, when a girl child asks for an abortion, it is against your religion or culture. You do not have to do it, but you have to, must. That is the law. Refer that girl or that woman to someone who will help her. In the private sector, the doctors have a choice whom they want to treat and who not. They also have a choice when they will be open or not. So in the private sector, doctors can decide to play golf on Wednesdays. It is their choice. They can do that. They can also decide that they will only focus on certain illnesses, but they cannot discriminate. In other words, you cannot have a doctor in private sector and he then decides he's only treating white people. That will be a no-no, because that is blatant discrimination and that will not be allowed. You can also not have in the private sector a doctor who decides he will not treat homosexuals because he has a problem with them. No, that is discrimination that will not be allowed. But he or she can decide that they don't want to open their offices on a Wednesday, they want to play golf. So they have more freedom. But also in the private sector, if a girl child comes, because it's lawful in South Africa to have an abortion, and this doctor doesn't want to do it, he or she has a duty to refer them to someone who will do it. So there's more leeway in the private sector because these people are working for their own accounts. In the public sector, all healthcare workers are employees of the state. So that is very important to remember that. Another thing concerning the private sector that you should remember, doctors working in the private sector, in other words, doctors operating and working at, let's say, Netcare, Mediclinic, or Life Hospitals, or Busamed, or wherever, they are never employees of that hospital. Doctors or physiotherapists or psychiatrists or speech therapists or any other therapist, but they work at that hospital. They are all independent contractors and not employees. In other words, if something goes wrong with an operation in a hospital, you will sue the hospital, which will be a private company, but you will sue the doctor in person because the doctor is not an employee of the private hospital. Nurses are a little bit more difficult. You get different nurses. So some nurses will be employees of the hospital, of Netcare or Mediclinic or Busamed or Life. They will be employees. But you also have labor brokers that provide nurses on a day-to-day basis as there is necessity. Then they are not employees of that hospital. Then you will sue the hospital, you will sue the nurse in person and the labor broker or the agency that provided the nurse. So keep these things in mind. And then also remember that our Constitution have the right to human dignity in Section 10. Human beings are entitled to be treated as worthy of respect and concern. Here I want you to remember that it is not just dignity that the doctor must have towards the patient, or the nurse towards the patient, or the patient towards the nurse. It is dignity for everyone, for the patient, but also the patient's family, also the staff that works there, but also remember dignity for yourself. Because if you remember that, then you will treat every person that you come across with this necessary dignity. Okay, I think this is a good point to stop for 5 minutes. So you can just gather your thoughts. You can just stretch for a little bit and maybe record questions if you've got questions. So I'm going to be silent for 5 minutes and then we will resume again. Okay, I am back and let's carry on. We are still busy with the Constitution and the effect that the Constitution will have on medical law. Then, of course, we have in section 11, the right to life. And there you will see the court case of Stransom Ford versus the Minister of Justice. It went to the High Court in the Gauteng province. And then eventually it went to the Supreme Court of Appeal. So the Minister of Justice then appealed and it went there. So these two cases are very interesting. Mr. Stransom Ford had cancer and he was suffering enormously with pain. And then he approached the High Court and he asked the High Court to be given the right to die. In other words, but he wanted to be assisted by his physician. So he wanted High Court to give him the right so that his physician can help him and then that he can end his life, because he was older and he was in immense pain and there was just nothing left anymore for him to live for. But he did not want to commit suicide. If you commit suicide, let's say, for example, you shoot yourself in the head, it is messy, and then people must come afterwards and they must come and clean up, or they might think differently about you because you committed suicide. So he didn't want to go the route of suicide. He wanted the court to give him the clarity that if his physician helps him, in other words, gives him something to drink, and he eventually dies, that the physician will not be prosecuted and it will not be a crime. Unfortunately, on the day that the judge in the Gauteng High Court gave the judgment, Mr. Stransom Ford died. Yet the judge went on and gave judgment in his favor, but he was already dead by then. But the judge felt that this is a crucial issue that judgment should be given on, and he gave judgment in favor of Mr. Stransom Ford and said he could be assisted in dying. But then the Minister of Justice and Correctional Services took it on appeal to the Supreme Court of Appeal. And the argument there was that the judge should not have given judgment because Mr. Stransom Ford died before the judgment was given, and therefore there was no basic cause of action and no need to give the judgment, and they were successful. So unfortunately, in South Africa, it is still illegal to be assisted to die. But I refer you there to a Canadian case, Carter versus Canada, 2015 case, in which Canada now recognize the right of physician-assisted suicide. This is a very topical issue in medical law, and we have a right to life in section 11, but we do not have a right to die. Not even if you are in immense pain, not even if you are very old, not even if there is no prospect of recovery, we do not have a right to die. And therefore, doctors have a duty to keep you alive. Now, you might come across clients that will ask you to draw up a living will. A will is a document that you leave behind in which you state what should happen with all your possessions after your death. It should either then go to your husband or your wife or your children or whatever. A living will is when you are still alive and you are completely compos mentis. In other words, you understand what you are doing, and then you write a document in which you say, should you be in a scenario where machines are keeping you alive, then the machines should be switched off. that is your wish. So you put it in what we call a living will. Or you can also in your living will say, if you die and they can use your body for research, or they can use your organs for organ transplantation, etc., then you put it in what we call a living will. But it is very important for you guys that are now becoming specialists in medical law that you should understand the living will has no legal status in the South African legal system. What do I mean by that? I mean that you cannot sue someone who did not give effect to a living will. A living will is not a basis for litigation. A living will is only a directive. It is only a directive. It is not a will per se, and it cannot be enforced by way of litigation. In other words, it is just a directive to the family members if they need to take a decision either to switch off the machines or to donate your organs. It can help them with making a decision, but if they don't follow that decision, there will be no legal recourse. Of course, you will be dead and you will not know that they don't follow it, but a living will is not a legal document. Just an interesting thing, if you ever work with clients and they ask you to draw up a living will, which you will be able to do, and record all their wishes, just remember, if they say they don't want to be kept mechanically through machines alive, just remember to also talk about feeding, because sometimes people in a living will say, I don't want to be kept alive with machines, in other words, artificially. And then the living will is there, and the family members will then sit together and they will all decide it was your wish while you were living that the machines should be switched off, and then the hospital will most probably do it. But that will not necessarily mean that you will die, because if they keep on feeding you intravenously by way of a drip, you can still carry on living and it will be a meaningless life. So when you draw up a living will for a client, remember to also specify that they should not just switch off the machines, but they should also stop feeding you. Remember, it is not bad treatment. It is you are unconscious and you will not even know that you will not be fed, and then you will die. But I want you to remember that in South Africa, we do not have a right to die. In other words, you cannot ask for euthanasia, and you cannot ask to be assisted by a doctor to let you die. As I've said, it is now legal in Canada. It is also legal to be assisted by a physician in the state of Oregon in the USA. It is also, euthanasia is legal in the Netherlands. But in Oregon and Canada and the Netherlands, you need to be a citizen in order then to ask for euthanasia, or in order to ask to be assisted by a physician if you want to die. In Switzerland, you need not be a resident. So Switzerland has what we call euthanasia tourism. Any person can fly to Switzerland. The place is called Dignitas. And then if there's proof that you are terminally ill and you are going to die, let's say in 3 or 6 months, you can go to Dignitas and you can have a physician that will then give you something to drink, and you will die in peace. The question that I would like you to think about, and I do not have the answers, it has not been tested in our legal system yet, but it can challenge your mind for a few minutes. Let's say my husband is diagnosed with cancer, and the doctors say the cancer is all over the body, so he will have maximum 3 months to live. But during that 3 months, things will become so bad that at the end he will be in so much pain that he will not recognize me or the children anymore. And then let's say my husband makes the choice and asks me to help him so that we fly to Switzerland because he would like to die in a dignified way. He would like to say goodbye and thank you for everyone who loved him, etc. But he is already in so much pain and so unhealthy that he cannot do the bookings, etc. So if I do it, I do the bookings, I organize everything, we fly there, my husband says goodbye. It is very sad, but it's done peacefully, and I fly back. There is a conundrum. Was I guilty of assisting him in death or not? Because what you get in Switzerland, if you die that way, is you get a death certificate that will state an unnatural death, and it will state physician-assisted suicide. Now, it is not a crime in Switzerland, yet it is a crime in South Africa. So what do you do then? There's no clarity yet, and the courts will have to decide on it, because then when you go to Home Affairs in South Africa, you will get a death certificate, but it will also state unnatural death. And for all unnatural deaths in South Africa, a police investigation is necessary. But what will they investigate? Because he died in another country. Reason why these things are all important is for the estate, because you need a death certificate stating the cause of death in order for your will or the estate, so that it can be inherited and it can be finalized and your insurance can pay out, etc. So this is a difficult one. I just leave it in your thoughts. There's no specific answer yet what to happen. But currently in South Africa, no one has a right to die. Euthanasia is illegal. A living will is just a directive with no legal status. Remember that for your practice one day. Okay, we've spoken about equality. Now, effect has been given to the right of equality through the Promotion of Equality and Prevention of Unfair Discrimination Act. Remember, I told you that a doctor cannot decide that he will only treat black people or only white people, or he will not treat homosexuals. You can't do these things. You will be violating the right to equality. The part in the Constitution very important for medical law is Section 12, which is the freedom and security of the person, because that gives you the right to decide for yourself. Keep that constantly in mind, because as we carry on, we will discuss informed consent, and we will discuss a patient's autonomy to take decisions, and all those things then revert back to the right of freedom, of security of the person in Section 12. And that is why I've put an exclamation mark there, because it translates to informed consent. Then you have the right to privacy, Section 14 of the Constitution. And at the beginning, I spoke about the website of the HPCSA. They have a little booklet where they also talk about confidentiality and privacy and what is expected of physicians when they violate that, or how should they do that, how long should they keep the records, etc. Then the other right in the Bill of Rights in the Constitution is the right to access to healthcare. And you will see that I've highlighted access, because sometimes people just loosely speak and say But in South Africa, everyone has the right to healthcare. That is not true. Everyone has the right to access to healthcare. In other words, there's a huge difference between having the right to access healthcare and having the right to healthcare. So be careful that you, who has now done this course, never speak of a right to healthcare. It is always the right to access to healthcare, and that every person have. But then there was a court case in the Constitutional Court, the one that you see there, Subramani versus the Minister of Health, and it comes from KwaZulu-Natal. Mr. Subramani had kidney failure. In other words, his kidneys didn't work anymore. And then if that happens, you have to go on dialysis. So you are put on a machine that then do the work of your kidneys, until such time that maybe a person dies brain dead in such a way that you can take the kidneys of the dead person and transplant it into the person's whose kidneys doesn't work anymore. Mr. Subramani was on dialysis in the private sector. In other words, he paid for it himself, or his medical aid paid for him. But you have to go on dialysis about 3 to 4 times a week, 3 to 4 hours. So it takes a lot of your time. You actually cannot have a very productive life if you have to be on dialysis. And that happened with Mr. Subramani. He couldn't work anymore, and then he didn't have medical aid anymore. So he then approached the public hospital in Durban, and he asked them that he wanted to be on dialysis. They then told him they cannot accommodate him on the dialysis program because they do not have enough dialysis machines. Now, because they do not have enough machines, they have certain criteria that you must comply with in order to then have the use of a dialysis machine. And that criteria is applicable in the public sector, and it basically states you need to be below a certain age. If I remember correctly, it's 55, and you should not have any other illnesses. In other words, you should be a healthy person, a transplant candidate. So if you comply with all these requirements, you are put on the transplant list so that an organ transplant can take place. And if you cannot be on that list, then they will not put you on dialysis because then you're taking up the space of someone else. So they refused that Mr. Subramani could go on dialysis. He then went to court and eventually ended up in the Constitutional Court, where he claimed he had a right to emergency medical treatment. But the court then, so there's 2 reasons why I want you to read this case, because the Constitutional Court then explained in detail what is meant with emergency care, and that dialysis is not emergency medical care. And secondly, they said that if the state does not have enough resources, that is acceptable. That is an excuse not to accommodate him. Now, I've got a lot of feelings about this court case. You can read it yourself. I think it's too easy for the public sector to just pull up their shoulders and say, sorry, we don't have the resources, so we can't help you. So what in actual fact happened in a country with a right to life, Mr. Subramani was sent home and he eventually died. Because if you do not get dialysis and you've got kidney failure, you will eventually die. But the public sector will not, or you cannot accuse them, because under this court case, they have the right to only supply if they do have the necessary resources. And the second thing that you must read the case is to see what is seen by our courts as emergency medical services, because remember, everyone in South Africa, even illegal immigrants, asylum seekers, all of the people, everyone have the right to emergency medical care. So that is a different right that you have. Apart from the right to access healthcare, every person, whether you are in our country legally or illegally, have the right to medical care. But in that case, it was said that dialysis is not emergency medical care. Then always remember, when you are faced with facts and it's a child, you have to, apart from the Constitution, Section 28, you have to look at the Children's Act, and then if it concerns anything with pregnancy, you also have to consult the Choice on Termination of Pregnancy Act. The bottom line of Section 28 and the Children's Act is the test where children are concerned is always the best interest of the child. Whatever decision is taken, it should be to the best interest of the child. And here I just want to warn you about the Children's Act. According to the Constitution, you are a child if you're below the age of 18. So 18, if you turn 18, you become an adult. But the Children's Act have different stipulations, and the Children's Act say that a child of 12 years and who has the maturity to understand what's going on need to consent for medical treatment, and they can consent to an operation. Their parents must just, or guardian, must give assent, but it is the child that decides. So warning lights must go on immediately if you are faced with a scenario of children. And don't think that a child is just below 18. So if you are given a scenario, let's say in the activities, or you read a court case and it is a child of 15, then the red lights in your mind should go on, because then you cannot just focus on the Constitution. You have to take cognizance of the Children's Act. You have to determine from the facts whether it's a mature child. If it's a mature child, then 12 years, the cutoff for medical treatment or giving consent to an operation. Now, just as a matter of interest, let me give you a scenario. Once again, it is just for yourself to decide what would or should happen. There was a girl of 13. So your red lights in your mind goes on, 13. From birth, she was ill. There was something wrong with her heart. And it was an operation, and then she's out of hospital. And it's back to hospital and another operation. So it's back and forth, in hospital, out hospital. She's 13, she didn't have a normal childhood as a toddler or as a young child, because constantly she was ill and it was operations and operations. So one day the cardiologist calls the child of 13 and the mother and the father, and he discusses with them and say that this child will die unless she gets a heart transplant. So he would like the consent that she be put on the list for a heart transplant, and if a heart becomes available, that they will do the operation. And so he asks for consent, and the child refuses. Now the child is 13. The child refuses and say she's tired of being ill, and she's tired of all the operations, so she's not giving her assent. She does not want to have the operation of a heart transplant. Now, what now? In the South African scenario, that is where everything should basically end, because she's mature, she's above 12, and she's not giving consent. Even if the parents talk to her and say, but it's a last chance to keep alive, if she refuses, that is it. But now we have the Constitution that is above the Children's Act that say everything must happen for the best interest of the child. So what happened in this scenario, the doctors approached the court on an urgent basis and then argued on the basis of the best interest of the child, and then it became a court order that the child should have the heart transplant. Now, everything seems fair enough, but how? Will you take the child and will you put her on a bed and force her and bind her legs together, or what? What do you do? Fortunately, when the court order was given, the child then said okay, and she went for the heart transplant, and it was a huge success, and she's still living. But this is the kind of questions you might come across depending on where you are going to work or what you are going to do with your knowledge on medical law. It is sometimes difficult. It is sometimes difficult because you have the rights of the children in the Constitution, but you also have the Children's Act. And then I've just added, if it's anything with pregnancy, remember that a girl child of any age can consent to the termination of a pregnancy. So I'm giving these things to you so that you be aware, whether it's asked in an activity or whether you come across it one day in your practice. Be careful when you are working with facts concerning children. Then the Constitution also gives the right of access to information, and that means specifically that is now where you are going to ask for records, hospital records, pharmacy records, doctor's records, and don't think they're keen to give it to you. They have this excuse and that excuse, and then under the Promotion of Access to Information Act, you can demand it. They will not give you ever the originals. They will give you copies of the hospital records and you will have to pay for it. But they cannot refuse. And in this instance, remember the book of Van der Heever and Lawrenson, which I've indicated, which will help you a lot to see how you go about requesting the hospital records or the records of the doctor on the basis of that act. A case that you can also read to help you to see how the courts interpret that act if things doesn't go right is the Unitas Hospital. It is a private hospital versus Van Wyk. Van Wyk is a wife of a husband who died in the Unitas Hospital, and she wanted access to information of research that was done in that hospital concerning septicemia. They didn't want to give her that report on the research being done. Then she approached the court. The court said yes, she can have that information. And then the hospital went to the Supreme Court of Appeal. They appealed the judgment, and the appeal was successful, where the Supreme Court of Appeal said she doesn't need that report because nothing in that report on septicemia has any causal link to the death of her husband or anything to do with her husband, and then they refused it. But a nice case, you can read both cases, the High Court case and the Supreme Court of Appeal court case. Read it to see how the law, the courts interpret this. But remember, when you deal with a possible medical negligence case, you have the right to get hold of the documents and the records. And just remember another thing. I might repeat this again, but I remember it now. If it is not written down, it did not happen. If it is not written down, it did not happen. So sometimes you will come across a alleged medical negligence case. Something went wrong in a hospital. For example, the patient didn't get the medicine and therefore developed a blood clot and eventually died, whatever the case may be. And you are confronted and you get the records, and the records are clear that that medicine was not given to the patient. Yet, when you speak to the nurse say, but I gave him the medicine, and she has an eyewitness that she actually gave him the medicine. Not good enough. If it is not written down, it did not happen. So if it is not written on the records of either the doctor or the hospital, it did not happen. If the doctor say, but I told this patient about the pros and the cons and the risk of the operation, we did it orally. But there's no indication in the file where the doctor made a note and said, I explained everything, the patient gave consent. If it is not written down, it did not happen. So keep that just at the back of your heads. So here on this slide, I have listed some constitutional court cases. Remember, in law, we've got the precedent system where the highest court is binding on the lower courts. So it's always very good to take cognizance of the constitutional court cases, because that is the highest court cases and they are binding on all the other courts. First one is Subramani. We've spoken about that. That's the guy with the dialysis, and where the constitutional court said if the public sector doesn't have the resources, they don't have to give the dialysis to the patient. The second one is Tshabalala Mzimang versus Makanya. I don't know, you might be a little bit young, but we had a Minister of Health, Dr. Tshabalala Mzimang. She then needed a liver transplant. There were allegations that she drank a lot of alcohol, and then she went to hospital for the liver transplant, but even in hospital there were allegations that she still consumed alcohol, and then it was published and there was an argument that her right to privacy was violated. H versus Fetal Assessment Center. I will come back to this one in the other webinars. I'm going to go into detail about that case, but that concerns a claim for unwanted birth, unwanted life. That is, the parents went to the assessment center, the fetal assessment center. They said to them, you must do tests on my baby in utero, in my tummy, and check. Because if there's any deformities or any sign of Down syndrome, we would rather opt for abortion and not have the child. Be it as it may, the baby was born severely disabled, and then the parents instituted action against this center for not being negligent and not giving them the right information. But they did this, the baby was then already 6 years. Now you must remember, in civil cases, prescription is after 3 years. So they went to the High Court in Cape Town on the basis of that it is the child that claims. The child then claimed and said, I should never have been born. This is an unwanted life. And then the opposition came with an exception and said that there is no such a cause of action where a child can go to court and say, I should never have been born. Therefore, an exception, and the High Court sustained it and said there's no cause of action. Then the parents did not go to the Supreme Court of Appeal, because there is a case which you will see later in the next webinar. they approached the Constitutional Court directly, and they said that the common law should be developed so that a child who is disformed or disabled can claim in his or her own name for an unwanted or a wrongful life. And then the Constitutional Court said they will allow it, but it must go back to the High Court, and each case will be dealt with on its own merits. But you cannot raise an exception anymore against a wrongful life claim. Very interesting case, very nice to read. So if you have time, worthwhile reading that case. Lee versus Minister of Correctional Services is a difficult case. It's a thick case, so you can just scan through it. There you will get answers on causation. How does the courts interpret causation? That guy obtained TB in the correctional services, and how it was proved that he was with a lot of inmates, and because of that he got tuberculosis, and whether correctional services is then responsible for what he suffered. Is there a causal link between what correctional services expected of him and the fact that he contracted TB? The next one is Opelt versus the Department of Health of the Western Cape. Very sad case, and I would love it if all of you will read it for the only sake of seeing that there are opposing expert witnesses. Now, the question is, when you go to court on alleged medical negligence, of course you have the plaintiff and you have the respondent, or what the case may be, which is usually either the private hospital or the public sector. Now, both these parties will get a team of experts, because you need an expert to come and say that the doctor or the hospital who is allegedly guilty of negligence did not act like a reasonable doctor or a reasonable hospital. We will do this in the second webinar. So now there's these two teams, and these are real experts in the field. How does the judge decide which one he or she favors or believes? And in Opelt, it is a rugby player that got a neck injury, and he was moved from pillar to post, from this hospital to that hospital to that hospital. Eventually, a lot of time was wasted, and he ended up being paraplegic. And then he had a team of experts, and of course, the Department of Health, the province of the Western Cape, they had their team of experts. And then the Constitutional Court gave judgment. There's a majority judgment and a minority judgment. Now, my heart goes with the minority judgment. I did not like the experts that the state have, but you should read it for yourself and decide. The next one is the MEC of Gauteng versus DZ. Very interesting case, and I think a very important case if you are going to practice in medical negligence, because that concerns quantum. How? Because if a child is being hurt, for example, born with cerebral palsy, then the damages you are going to claim will be an enormous amount, because it will be to sustain the baby, to look after the baby, meaning nappies and medicine and milk, etc. But that baby becoming a young child will also need certain specific therapy. And then the child could have become a teacher. So you will claim for all of that. And that is why I said that sometimes the claims is more than 20 million, and it has to come from the budget of the province. Now, in that case, the Constitutional Court said that depending on the facts of every case, maybe the law should be developed that you do not pay in one amount once and for all, once off. As it is currently in our legal system, when you claim damages and the parties agree and it becomes a court order that damages of 12 million must be paid out, then that 12 million must be paid once and for all. In other words, you can never claim again, and it must be paid in rand. So you will get your 12 million to help you then to have a comfortable life. In that case of DZ, the court said there's no need to stay with a once and for all or in rand. In other words, they opened the doors, depending on the facts of every high court case, that maybe the judgment in future can be not that 20 million must go to the parents of this child to sustain a child of cerebral palsy, but that that child should get the services from the state sector to help him or her to live a comfortable life. So it's quite important, it's quite recent, take note of that. If you work in road accident fund matters, then the next one could be applicable of the Minister of Transport or the case of Ronald Bobrov. So though the last two is more applicable if you work on RAF matters, but this course is not focusing on RAF matters per se. So I've just added that for the few of you that does that. Okay, so in order to come to a conclusion, more or less for today, I have said that when you institute action for alleged medical negligence, you can either do it on the basis of a contract or on the basis of a delict or both. And what are the requirements for a delict? It is there must be conduct, human conduct. It must be wrongful. Fault must be established. Causation, most important thing, and then damages. If you sue on the basis of a contract, those are the elements for a valid contract. Consensus, capacity to act, physically, it must be physically possible, it must be legally possible, and then damages must be, you must be able to calculate damages. So if you want to see an example of where a medical negligence case was conducted on the basis of a breach of contract, then you can read Administrative of Natal versus Edward. You will see it's quite old case, 1990, and it went to the Appellate Division. And that's before 1994, it was known as the Appellate Division. It then changed to the Supreme Court of Appeal. So that A just indicates Appellate Division. So Mrs. Edward, she gave birth to a child and she already had, if I remember correctly, 2 children. And with the birth of the third one, she wanted to be sterilized as well. In the public sector, the doctor did not do the sterilization. She fell pregnant again, and then she sued them for that she didn't, unwanted pregnancy. They will keep the child, but they didn't want more children because they couldn't afford more children. So she claimed the money from the Natal administrator. Remember, it's the old South Africa. Then it wasn't the MEC yet, and they had to pay her out the costs, only the cost to sustain the child. Mrs. Edward could not claim pain and suffering for going through another birth because they only claimed on the basis of a contract. So that's very interesting, and it's nice reading to see how the courts argue if you claim on the breach of contract. Then there's another case that I would like you to go and read or take cognizance of. It is Afrox versus Strydom. It went to the Supreme Court of Appeal, and it concerns exclusionary clauses. When you are admitted to a hospital, especially a private hospital, they will put a lot of forms in front of you and you will have to sign all of it, and that then constitutes a contract between you, the patient, and the hospital, the private company, the hospital. And then if you read it in detail, sometimes people do not read it, they just signed it. But there will be exclusionary clauses saying that the hospital group or the hospital company is not responsible for any damages that you may suffer. Now, if you draw a line through these clauses, then you will not be admitted. If you are admitted, then you indemnify them for any damages that you may suffer. So Mr. Strydom took them to court and said this is unfair. You cannot do it. I cannot sign away my rights and then you are indemnified. But unfortunately, the Supreme Court of Appeal gave judgment against him in the appeal case, and they gave judgment in favor of Afrox, saying that these exclusionary clauses in the contract between the patient and the hospital is valid. So this is the current position. Although it was done in 2002, it is still the current position that these exclusionary clauses are allowed in the contract between patient and hospital. But then after 2002, the Consumer Protection Act came into play. And under the Consumer Protection Act, those exclusionary clauses will not stand anymore, but it has never been challenged in a court of law. Therefore, the Afrox case still stands. Remember, I told you, you are law students, the precedent system. It's a Supreme Court of Appeal judgment, so it stands, and all the lower courts are bound by that judgment until it is changed either by the Supreme Court of Appeal or a higher court, which then will be the Constitutional Court. So the exclusionary clauses are still valid until such time that someone will go and contest it. But now, under the Consumer Protection Act, which became effective after the judgment of Afrox. And I want to apologize from the very beginning. The Afrox case is only reported in Afrikaans. I don't know why, but it was a decision from the Supreme Court of Appeal, so I've got nothing to do with that. I plead not guilty, so you can only read the full case if you can understand Afrikaans. But if you Google Afrox and Strydom or any medical negligence book where there's summaries on the Afrox case, you will find it in English, but it's only reported in Afrikaans. Okay, that then concerns a contract. So go and read Administrative of Natal versus Edward to see how a contract is applied. But as I've said, nearly all the medical negligence cases goes on the basis of a delict. So you have to know what are the requirements for a delict: conduct, wrongfulness, damages, causation, and fault. And as I've indicated, the biggest difficulty in alleged medical negligence cases is to prove the causation. That what the doctor did, that led directly to the damages. If the doctor did not perforate the artery, the patient would not have died of blood loss. If the doctor performed the sterilization, the woman would not have fallen pregnant again. So there must be a link, and that is difficult to prove. But that is the crux of the matter. Okay, then to end off, does a doctor have a duty to treat? Not always. Remember, I said in the private sector, they can decide as long as they do not discriminate. But once a doctor, whether it is public sector, whether it's nurse, it doesn't matter. Once you've started, a physician started treating a patient, he or she have to complete it. They have to complete it. In other words, if you go for an operation, you see the doctor before you give consent, the operation is done. The doctor will be responsible for the aftercare until you leave that hospital. A doctor cannot abandon you halfway. They have to complete. If, for example, they have to go overseas, they have to hand over to a competent doctor who will then complete the treatment. Is there a duty to get informed consent? Yes, yes, yes. This is the most important part. Is informed consent. Remember, I said it links with Section 12 of the Constitution, your right to self-determination. Informed consent is not the same as consent. There's a difference. Informed consent is you need to know everything. You need to know the risks, you need to know the pros, you need to know the cons of everything that the doctor is going to do to you. And informed consent is specific. In other words, if you need physiotherapy and they're going to start a program for 3 months, you must give informed consent that you will follow that program for 3 months. If after 3 months, as part of the treatment, another program is followed, the physiotherapist must get new consent. You cannot have broad consent for everything. For everything that a doctor will do to you for that specific thing, informed consent is necessary. Where will you get information on what is informed consent or what constitutes informed consent? Please go and read Castell versus de Greef. You will see it's old, it's 1994, but it is the locus classicus on informed consent. It still stands today. And when you read newer and newer court cases, they will always refer back to Castell versus de Greef. Then go to Section 7, 8, and 9 of the National Health Act, who also indicate there how and who must consent and who can consent if a person is unconscious or lacks consciousness or not able to consent. Who can then consent on his or her behalf? But remember, and I see I haven't even added it there, children, 12 years and older must give their own consent. Then go to the Health Professions Council of South Africa, HPCSA's website, and you will see there's a specific booklet also explaining what is informed consent and how it should be given. Then there's 2 cases. Isaacs versus Pandi is the High Court case, and then you see the reverse because it went on appeal. That is where there was a dispute. The lady wanted to be sterilized, then didn't want to do it anymore, then wanted it again, and there was miscommunication, and eventually a sterilization was done, and then she assumed that she did not give consent to that sterilization. And you can see it's quite a recent case, so it's worthwhile going to read these 2 cases. Then the last one there is RB versus Smith. It's a 2019 case, also concerning informed consent. The doctor explained one procedure, then under operation decided to do another procedure, and then the woman said, but he did not have informed consent, but judgment was given against her and in favor of the doctor. Now, there's a lot of controversy on this case. A lot of academic scholars have written about this case and said that the judgment is wrong. You decide for yourself, but it's a 2019 Supreme Court of Appeal case, so it is definitely worth reading to see how arguments developed concerning informed consent. Okay, and there I just give you that someday it was alleged that there is nothing like a delict in our legal system because there's no acts specifically explaining it. And of course, you know that that is nonsense. A law of delict is part of our common law, and with the delict goes a general duty of care. So a doctor, the moment he starts treating a patient, has a duty of care, and he must do it on a certain standard of care. And if he or she deviates, then there could be negligence, not necessarily is negligence. Okay, these are questions that previous groups have asked and said that the reasonable doctor test is never really objective. We try to be, or we call it objectivity of the standard of care test. It is, if we have to go between very fine lines, yes, it's always subjective, but it's called an objective test. I've spoken about abortions in the public sector. I said you have the right if you've got religious or cultural things that will not allow you to do an abortion. You can refuse, even though you are an employee in the public sector, but you have to refer that girl to someone who will then do it, because abortions are legal in South Africa under the Choice of Termination of Pregnancy Act. Then I got questions previously that in the multiple choice questions, sometimes we speak of a preponderance of probabilities or a balance of probabilities. They are the same thing. See it as synonyms, it means exactly the same. Okay, so before I end off, if you do test one, I don't know whether you've done it and whether you are still going to do it, but as I said, test one will cover all the work in your official study material. The questions was put in such a way it is not to catch you out. It is the straightforward answer is the correct answer. The only reason why we give you a test is we want to force you to read the study material, because if you read the study material, you will follow the webinar and you will be able to do the activities. But there's nothing funny in the multiple choice questions. It is straightforward. It is not technical, so the first correct answer is the correct answer. We are not trying to be funny. Remember, this is the introductory module, so we're asking it straightforward, and we're not hiding behind the bush and want to see whether you know everything in the most fine detail. That is not what we're aiming at. We just want you to go through the study material. And then lastly, remember to do your best with your portfolios. You've paid now for this course. It is extremely interesting. People ask me, why am I so passionate about medical law? And then my answer is because it overlaps with so many different legal fields. It's the law of delict, the law of contract, constitutional law, a little bit of labor law because you work with employees and employers. And then there's a big part also of ethics. Sometimes medicine does not have the answer, and you have to fall back on, was it ethical or not? In conclusion, and this is now just speaking straight from my heart, I think the biggest problem why we have such a high number of court cases on medical negligence, alleged medical negligence, is a lack of communication. For some or other reason, doctors or health specialists do not communicate. They do not explain what is wrong with the person, and if that person then eventually dies, they do not talk to the family to explain to them. And this is sad, because while I was practicing as an advocate, and you see the clients who wants to institute the action against the physician, it is most often not than not because they are angry. They are angry, they do not understand what went wrong, either in the treatment or in the hospital. So they want answers, and then they think they will get it through a way of court cases. Yes, they may, yes, they may not. So please do not think that medical negligence is a quick way to become very affluent as a lawyer or to make a lot of money. These cases, and you will see that in the South African Law Reform Report, it takes sometimes up to 10 to 16 years. These cases are extremely expensive, and it's extremely difficult because you have to find yourself an expert to come and testify, and doctors do not like testifying against each other. So that is an obstacle. Number one, to find an expert. Experts are expensive, and the court cases will take years. So it is not a quick fix to decide, I am now specializing in medical law. But if you take that decision, I think you're going to love it, because it's extremely interesting, and yes, it's a unique field. So thank you to all of you that listened to my boring voice. I hope you learned something. Remember, there's 2 more webinars to come. In the meantime, do your activities, and if you've got questions, send it to Bonnie, and me and Bonnie will try to answer to the best of our abilities. So thank you very much for listening to me, and we will speak again when it's time for the second webinar. Thank you so much. Bye-bye.